all right? You got a plan for it. You know, if you get up on top of the roof and jump off, probably got to be some bad stuff happen when you hit the ground. Might be a good time on the way down, but it's not going to last very long. Then you're going to hit the ground.
Yeah.
That's life. That's part of growing up and being an adult. Okay, so I hope you're on the way to doing that.
Yes.
So I applaud that. Okay, so I'm just going to give you a small fine on both of these because I figure you don't have a whole lot. Don't have a whole lot of money laying around, right?
And I could set up like a payment plan, right?
Yeah, you can even do community service to pay. I'll let you work community service to get rid of it rather than pay.
All right.
And you can do it at the Portsmouth Municipal Court and they'll transfer it here. But you look, sounds like you're already getting to know those people, right?
Yeah, I'm on probation there.
Okay. All right, on the speed offense, $30 fine, and on the no driver's license, a $50 fine.
All right, I could probably really pay that.
Okay, and you got court costs to pay too.
All right.
110.
All right.
You can pay it today, or you need time to pay it?
Well, I probably need a few weeks to pay it, but.
Okay. Well, I guess we have to put her on probation. She doesn't have a license, so then the last payday wouldn't work. Okay, so I'll put you on level 5 probation, which means no, you don't have to report except for a review hearing, which I'm going to set up October 23rd. So you got all summer and most of the fall to get this done. If
All right.
you don't, then you got to appear on October 23rd.
All right.
Explain why you didn't get it done.
All right.
And you're going to go meet with the probation officer. You can do community service to work it off instead of paying. And then you need to get a license.
All right.
Any questions?
No.
Your probation officer, when you go out in the lobby, make a 9-degree left back toward Portsmouth inside the building.
Yeah.
And his office will be right in front of you, that counter in front of you, just past the vending machine.
All right.
Go talk
Thank
to
you.
him, and then you're free to go after that.
All right. Thank you.
You're doing the right thing. Keep at it.
State of Ohio versus Tiana Creekmore. Case number TRC 20-1534, A, B, C, and D.
Okay, you had a review hearing last week, right?
Yes.
And you missed it?
Yes, I've been real sick.
Okay. All right, you've done a lot of your stuff. You still have some more to do. You did make a payment today?
I paid off my fine yesterday and then the rest of it today.
Okay. Can you tell us?
That's correct, I don't see a balance too.
Okay. You've got 8 hours of community service to do. So get that done and you'll be finished.
Alrighty.
I'll set your next hearing for April 24th. Get your community service done before then and you can not appear at that hearing.
Alrighty.
No warrant issued. April 24th is your next hearing, 9 a.m.
Thank you.
You're welcome.
State of Ohio versus Jennifer Stapleton. Case number CRB 2162, CRB 181240, CRD 183524, CRD 173143, A and B.
All right, Ms. Stapleton is here, and you had a hearing last week, right?
Sir, I did.
And what, you missed it?
Yeah, the woman I was bringing me, like, she moved out, so I had no way to get here.
Okay. And you, it looks like at this point you just owe fine with that.
That's just court costs, so
Can you pay anything on it?
I don't have anything today.
Okay, we'll work with you, give you some more time. April 24th will be your next one,
All right.
9 a.m. No warrant issued on the last missed hearing.
Thank you.
You're welcome.
State of Ohio versus Aaron E. Wenzel. Case number TRD 22963.
Okay, you were supposed to be here August the 9th for actually for the traffic court for a sentencing.
Yeah, I was.
And looks like you missed that hearing?
Yeah, I did. I was in a inpatient program at the time.
Okay, which one?
It was in Portsmouth, side of behavioral health.
Did you finish it?
Yeah, I finished it.
You went to OVP too at one point, didn't you?
Yeah, I was there for about 60 days, 50, 60 days.
Okay, this was on a no operator's license, and again, it was in traffic court, so you didn't appear, and that's why you're here, because there would have been a warrant issued since you didn't appear. You didn't get arrested, did you? You just came in and tried to get this taken care of?
Yeah, which I did. I just completed the DUI class this past weekend.
Okay, so you're gonna try to get your license back?
Yeah.
But you haven't done it yet?
No, that's what I'm in the process of doing.
Okay. Okay, rather than drag this out, I'm just going to impose a $50 fine and court costs. And I'll give you a last payday of June 27th. So what'll happen, if you pay it before June 27th, all's good. If you don't pay it then, it's going to go into the B&B, and that'll keep you from getting a license.
All right. Yeah, I'll probably just pay it this week.
That'd be great.
Yeah,
You
I'll
don't
probably
have to worry about it.
So is that the only thing that's holding me up? I just got to pay that and I'll be good?
Oh, I don't know about that, because, you know, any court from around the state could send something to the B&B saying you did something with them that could cause you from not being able to get a license. But here, that's the only thing you got.
The only thing I got.
Yeah.
All right, I appreciate it.
You're welcome.
State of Ohio versus Stephanie Romans. Case number TRC 173010 and TRC 171080.
Ms. Romans,
Yes.
okay, you were supposed to be here on March the 6th, right?
Yes.
And it looks like you didn't appear then for some reason.
No.
Do you have an explanation?
Yes, actually, I was working 6 days that week, and I actually forgot about it. I'm so sorry.
Okay. You just have fines to pay at this point.
Okay.
You finished your community service.
Okay.
Can you make any payment on your fines?
Not till the 31st.
Oh, I'm sorry. On one case, you finished your community service, on the other, there's still some left. So,
Okay.
did you get those dates that I gave you where you can get double credit?
No, I did not.
Thursday this week, which is March 23rd. March 23rd, April 29th, May the 6th. Those are all dates when you can get double credit. You come to court, 7:30 a.m. I'll set your next hearing for April 24th, 9 a.m. I'll cancel any warrant that had been issued.
Okay, thank you.
You're welcome. All right, let's recall Mr. Kent, Brian Kent.
Yep.
You've been able to work out anything?
Someone is going to assess him as soon as he leaves here, and then we can probably place him Thursday.
Okay, and will this be a situation where
We're going to try sober living
keep his job?
to keep his job.
Okay. What do you think about that, Mr. Kent?
I think I'll not mess up for another 2 years, hopefully.
Okay.
But I ain't saying I'm going to mess up. I'm just,
Well, Well, you know, we all mess up in some form or fashion. It's how bad or how much, what kind of consequences we have.
Yes, sir.
For you is to get clean, and you have shown you can do it, right?
Yeah, of course.
And you got a good job. So we want to keep those two things going. You clean and good job kind of goes together.
Yes, sir.
So here's what I'm going to do on this case. I'll give you a $150 fine, but I'll suspend all of it on the condition that you complete treatment.
Okay. All right.
And I'll suspend the court costs too, so you'll owe nothing as long as you complete treatment.
That's awesome. Thank you.
And I'll put you on a review hearing, because I want to keep track of you and see how things are going.
All right.
Let's come back in a couple of months.
Okay.
Let's make it May 19th.
Okay.
Thank you, Your Honor.
All right, May 19th, 9 o'clock is your next meeting. Good luck, sir.
Thank you.
You're welcome. Okay, we're ready to start pre-trials.
State of Ohio versus Courtney R. Hampton, case number CRB 22761.
Mr. DeWater's case set for pre-trial today.
Is Mariah Casey here? Mariah Casey? She's here. Oh, there she is. We're not able to resolve the matter today, Your Honor. If Mr. DeLauder wants us to schedule a trial, we can do that.
Yeah, that'd be fine, Judge. And what we expect is that there will also be criminal charges filed against the complaining party in this case in light of some evidence. So I don't know if we want to schedule them all on the same day. It involved the same basic incident.
Is that correct, Mr. Field, or?
Well,
will we have to have a special prosecutor then?
We received a video which purports to be an assault by the victim against the defendant. Now, there is some question about whether that is actually what we're seeing or not, but of course, Ms. Hampton has the right to report that to law enforcement and ask for a report to be made, and then our office would review it. Probably, it would probably result in the need for a special prosecutor. And we're willing to do that, if that's what it comes to.
So I don't know how
maybe
to
not a
proceed.
trial the next time.
Well, I think we'd want to sort all that out before we start I mean, I can just set it for trial, but would you prefer to see if that's going to be filed, and that may have some effect on it?
Seems like that would make more sense, yeah.
So if I'm reading between the lines, it sounds like what is being requested, that she first file a police report.
Yes, which she's we have not done that in anticipation of this being resolved. We thought that the whole thing would be resolved at once. It doesn't look like that's going to happen, so I'll have to have her actually file the formal report at this point. The video of the incident's already in the state's possession, so I guess maybe we should come back for a pretrial on this day, and then we'll know the status of the other case at that point.
So how long is that going to take?
Well, I'm going to have her do that today when we...
I mean, for the state to process it and decide, and if there's going to
be a special prosecutor.
Probably would have to be a special prosecutor on the other case, I would think.
I don't know how long that'll take, Mr. Hill, to
I'd say
assign
3
us.
to 4 weeks, I would think.
Okay.
To make sure it's done. So looking at somewhere mid-April.
So April 24th, is that too late in April?
It's fine with me.
Or April 10th, if that's better? Why don't we, can we do April 10th and see what the status is?
Yes.
Okay.
All right, April the 10th will be the next pretrial, 10 o'clock.
All right, thanks, Judge.
You're welcome.
State of Ohio versus Amber D. Ward, case number TRC 2316, A and B.
This is Mr. Waters' case, and it's a pretrial.
Judge, this one I've talked to Mr. Hield about this morning. There was a discovery's been completed in the case. There was an issue of restitution that Mr. Ward tells me has already been taken care of, but we still have the underlying charge to deal with. So I told Mr. Hield I intended to file a motion to suppress related strictly to the field sobriety tests. And I think we'd like to have a pretrial on that, actually, before scheduling it for a hearing. There is no breath score in this case.
And have that file ready for the pretrial on the 10th?
Yes.
All right, be pretrial on the motion on April the 10th.
All right, thanks, Judge.
State of Ohio versus Stephen T. Wells, case number TRC 222615, A, B, and C. Judge, on this one, today was the pretrial on the motion to suppress, and I do not believe we're going to be able to get this resolved without maybe the officer being here to tell us his side of things. So we probably need to go ahead and set this for a actual hearing.
You want to do April 10th at noon? For
Yeah, it's already been
hearing?
filed. That's fine with me, yes.
April 10th at noon for evidentiary hearing on the motion.
State of Ohio versus Jessica L. Thomas, case number TRC 2372, A and B.
Judge, on this one, Ms. Thomas has already pled guilty. We had continued sentencing in hopes that we could make a joint recommendation to treat this as a low-end OVI for sentencing purposes. However, Mr. Hield wanted to see Ms. Thomas's progress in treatment. So, if you recall from the last hearing, she was treating with a place called a Center for Change, but they discontinued the services. So she was doing everything she needed to do there, attending individual and group sessions, but she had to switch providers. So she's now with Mahajan Therapeutics, and
I have a letter from Mahajan, but she's just getting started with that.
Okay.
So I think Mr. Hill would like to see her progress a little more before resolving the case.
Right, okay.
Which is-
So we'll set this for another hearing.
It's a sentencing hearing, Your Honor.
It'll be a sentencing then?
She's been in treatment pretty consistently since this started. January 30th, I think, was her first treatment day. So I don't know how long Mr. Hill wants to see a pattern of compliance with treatment before he'll be comfortable resolving it,
Well,
or
we
the
don't have
court.
anything, we don't have any records from a Center for Change, right? Jeff?
I do.
Oh, you do?
Yes.
Did they go out of business or what?
They quit offering,
Yeah, they said as of March 31st that they was closing their doors.
Okay.
so,
We don't have any particular feeling about how long we should go out. We just, of course, want to have a report from Mahajan the next time.
Right.
you want to, is April 10th too early, or would you rather go?
I'd
a little
rather
longer?
do the 24th.
Okay.
I think it'll take that, I want to see a pattern of treatment. Okay, April 24th will be a sentencing hearing, 10 o'clock. And it'll be Mahajan. I'll need a current report from them at that time, the one they issued today.
Right. All right, good.
No, it's-
Keep doing what you need to do. Okay, thanks, Judge.
You're welcome.
State of Ohio versus Austin v. Benson, case number CRA 2394 and TRC 23131 A and B.
Judge, this is the one we discussed during pretrial conference. Mr. Benson was stopped twice, once by Chesapeake, got a speeding ticket there that he's taken care of. No indication of any impairment, but then immediately after he was left, the highway patrol pulled him over. The allegation...
Where this gun charge?
Yes, there is a firearm charge, but I believe Mr. Hill indicated to me he was willing to nolly that charge.
We're willing to do that, Your Honor. And I believe we agreed on a forfeiture of the gun.
Yes. The complicating factor, Judge, if you recall from pretrial, was that there was an allegation of a prior back in 2018 in the state of Kentucky, but after discussing it with Mr. Hield, I believe that we're both agreeable to recommend this be treated as a first offense for sentencing purposes. We don't have confirmation of the outcome of the prior offense other than a notation on a traffic record. And it's my understanding Mr. Benson intends to change his plea.
Mr. Eden?
We're in agreement with that, Your Honor.
All right, I read the report that the officer issued to the court. Mr. Benson, do you have any statement you wish to make?
Not really.
One thing I want you to understand, if I accept your plea on this case, this is going to go on your record, and I'm showing a record of a prior conviction in Kentucky. Now, states tell me they don't think they can necessarily find proof of that, but it's on your Kentucky driver's license record. If you take this case and it shows as a conviction, I'm not sure what the law is in Kentucky. In Ohio, it's up to a 1-year incarceration on a third offense. I know in West Virginia, it's actually a felony on a third offense. So another court could substantially increase your penalty if you have another offense.
Yes, I'm aware.
It would be, could be considered a third offense. Do you understand that?
Yes, sir.
You still wish to enter the plea that your lawyer is
Yes, sir.
stated to the court? Okay. All right, well, I have some trepidation about taking this with all the circumstances, with you having a prior and the test score and you having a gun in the vehicle. Those are all not good circumstances, and I'm hoping that this causes a light switch to come on.
Oh, it already has,
This
Your
kind
Honor.
of behavior is not acceptable.
I got too good of a job to mess up under situations like this.
Okay, on the OVI, it will be sentenced as a first. I'm going to impose a $750 fine. Order you to pay the court costs. You get a 6-month license suspension, and that starts the date of the offense, February 5th. 20 days in jail, all suspended on the condition that you do 5 days of community service on the court's community service program. You can have a permit for work, community service. You'll have to go to driver intervention program school, which is 3 days. Taylor will talk to you. Taylor will talk to you, it's out in the lobby, talk to you about the 3-day program. Mr. Major's going to be your probation officer. He'll talk to you about your probation. We've got some days coming up where you can get double credit for community service. Your first review hearing will be October 23rd. If you finish things before then, you don't have to come to the review hearing. That'll be at 9 a.m. October 23rd. On the lane violation, I'll impose a $20 fine. On on the improper handling. That's going to be nollied on with an order that the weapon be confiscated and forfeited and order destroyed. And it is a 380 Taurus Spectrum, serial number 1 F as in Frank 143571. Okay, you have 2 people to talk to. After you've done that, you're free to go. Any questions, sir?
Yes, will I be able to do my community service in the state of Kentucky, or will I have to come to Ohio and do it?
Well, you live in Olive Hill, so that's far enough away. I would let you do it there.
Alrighty.
You do it in your home area at a legitimate charitable organization or the court there.
Thank you very much.
Discuss that though with Mr. Major.
Alrighty, thank you.
Talk to the lady out there about the good school, talk to her, talk to the probation department.
All right, thank you.
State of Ohio versus Austin Neese, case number CRA 2385.
All right, this is Mr. Delauder's case.
I think we have a resolution here by Mr. Hill. What Mr. Hill and I talked about proposing in this case to resolve it, Your Honor, was to, in case 23 CRA 85, to reduce that charge to a misdemeanor of the first degree under the same code section. And then Mr. Neese entering a guilty plea to that, as well as the menacing charge that was pending. And as a part of the sentence, it's my belief that Mr. Hill was going to request the firearm be ordered destroyed.
Actually, we didn't come to that. I hadn't made a decision as to whether we were going to do that or not. I want to set the, I just said that about these men get rid of it. Or I can't guarantee that's what's going to happen, but it might happen. Let's do that.
Could we, I think Mr. Hill wants to talk to the other parties involved. We may have an alternate resolution that gets rid of this. Can we come? Yeah.
All right, case is continued to April 10th for a pretrial 10 o'clock.
State of Ohio versus Michael L. Shore, case number CRB 2315. Your Honor, this is really set for trial noon today, but it's my understanding that there has been somebody agreed to work out.
All right.
Your Honor, we have been working with the alleged victim in this matter because she has some concerns about the safety of her children and her dog in the community and whatnot. And the allegation has been that Mr. Shore, that these 2 dogs were involved in this, belong to Mr. Shore. He's contested that. However, we've come to an agreement that he will cooperate if the dogs are around where he is, and we're going to try to get the dog warden to round them up, although I think that they haven't been seen for a while. That's part of what the victim is telling us today, that I asked her several days ago to please identify these dogs with a picture or something. They're neighbors, these individuals are neighbors. Mr. Shore, it's my understanding, is going to pay the restitution for the vet bill of $114.30. We're going to ask to continue the case for approximately 90 days, and hopefully there's going to, number 1, be no further problems involving these dogs. Number 2, everybody's going to jointly make an effort to round them up and to get them out of the neighborhood. So we're going to hopefully have the cooperation also of the enforcement officer.
When's the restitution to be paid?
I have it now, so
Okay.
I can do that. If I'm allowed to, I can do it now.
Was it 114 even?
Yep.
1430.
30? Thank you.
Oh, 11430, okay.
That's what I wrote down, is that
Okay.
correct?
That's correct, Your Honor.
Okay, so he'll pay the restitution before we come back to court?
Yep.
And when do you want to come back, the 10th?
Well, actually, is that what Mr. Hill said? I think Mr. Hill wanted the case to be continued for another 90 days or so
Okay.
to allow these efforts to continue with the dog warden.
If it turns out that the dogs appear and they are taken out, and removed by the dog warden before then, maybe we'd ask to advance the date. But 90 days, I think, is the appropriate thing at this time.
June 19th?
I'm gone that week. I'll be back on the 23rd, I think.
Okay, do you want that date or the 26th?
Can we do the 26th?
June 26th will be the next day.
Do you want that as a pre-trial or a sentencing?
It'll be a pretrial.
And then Mr. Shores tried to get the dog warden out there repeatedly to deal with some of the animals. We don't think they're going to be of much assistance, but we're going to keep trying. Thank you, Judge.
June 26th, thanks.
State of Ohio versus Lonnie E. Morris, case number TRC 213013 A and B. Mr. Holt's case.
All right, Mr. Holt is representing Mr. Morris today. You know where Mr. Morris is?
I do not, Your Honor.
Okay, well, you'll have 7 days to appear before a warrant will issue.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kayla Schrader, case number TRC 221489 A, B, and C.
I believe there's some motions pending.
Yes, Your Honor, I have 3 motions pending now.
We're not opposed to having a hearing on the motions. There's one about getting the officers, what is it exactly?
Personnel file.
This personnel file, which we feel like if there's a specific thing that can be identified, I guess our opposition would be different than just saying we want his personnel file just as a fishing expedition. I think that what Mr. Holt's point is that he thinks that the individual who conducted the intoxilizer test in this case hadn't done it many times or hadn't done it in a while or something like that, but I think that he can be questioned in a suppression hearing on that issue to see if that has any impact on his ability to perform that test. I think the machine functioned properly, so.
Your Honor, our position is the normal course of these cases that the personnel file actually is a public record except for redacted information like address and social security numbers. So I think it's the normal course that the officer's personnel file is discoverable. Our whole case is built on, our cross-examination and impeachment of the trooper, so I believe that's relevant evidence.
Well, I don't think we've had this issue come up before, so I'd like to see some authority on that. And I'll just tell you what my thinking is off the top of my head without actually doing some research, because I could foresee that there would be personnel, obviously, information in the file of the officer that could be relevant, but there could be a lot of information that's personal that's not relevant either. So my initial inclination would be that it would be produced to the court for an in-camera inspection, and I would look at it, and if I felt like there was something there that was germane to the defense, then I would allow it to be seen by the defense. But I don't think, unless you got some authority, I don't think there's a basis just to allow you to have free access to the personnel file.
I can produce that, Your Honor. My representation of many political subdivisions in the state of Ohio, I've actually had to redact it myself. It's discoverable. I could get it through a public records request. I just didn't want to set that standard. I mean, if I do a public records request for his personnel file, they have to produce it within a reasonable time. The state has such better access to me, then it might create an unnecessary delay. But I can.
Well, give me some authority to it. I'm willing to be shown to be wrong because I haven't really looked at this issue. So
I will, Your Honor.
I'm just giving you what my thinking is without going to do the research. But I could be proven wrong. Give me some authority, and so I would do that without going further. But if you want just carte blanche access to the personnel file, then you'll have to convince me that there is a legal basis for that.
Understood, Your Honor.
If Mr. Holt gets me something that ensures me that we wouldn't be giving up some privacy of the officer or some legal barrier to it, then we don't have an opposition to it being placed in the court's hands for the court to review, if that's the way it turns out. So we don't intend to make this a huge contentious thing. We just want to make sure.
Okay.
I'll get authority for that, Your Honor.
All right. Well, I'd like to set another hearing date by which you can do that. When do you think that would happen?
I could have that by the end of the week, Your Honor. I think
When are you coming back?
I'm very familiar with that. I'm sure that I'll be back the 27th or the first week of April, or I'll be here the 10th for sure. If we'll do that on that matter.
Well, I'm fine with April the 10th if that's.
I don't know if the state probably wants some time to respond. I'm sure.
Well, that's 3 weeks.
That should be fine, particularly if he gets the information to us quickly.
Might be able to get it here now.
All right, I'll set it for, there'll still be a pretrial motion, but in particular, access to personnel file.
Thank you, Your Honor.
You're welcome.
State of Ohio versus John A. Barker, case number CRB 23115 and CRB 23116.
This is Mr. Smith's case.
It is, Judge. This is a February 20th arrest with a urine test. Sarah checked earlier today. They don't have them back. I'd like to come back. I could do the 10th, 14th, or 17th of April, whichever's less crowded on the court's docket.
Do we have any time issues here?
Well, we would, here's the thing too, there's also a domestic violence charge that's pending that occurred shortly
Before.
and she's here actually today, so we'd like to be able to address that issue too.
Let's look at it also and then decide on.
Yeah, I don't think, it's not, Judge, it'd be June 20th roughly would be the 90 days, so I don't think we have any timing issues for an April return. Today is the 20th. March 20th.
Okay. Your Honor, Elizabeth Goodall is here, and she's the alleged victim on the domestic violence charge. And her concern has to do with the fact that they have children together. And she wants him to be the best father he can be, and she feels that there are substance abuse and mental health issues that need to be addressed. February 13th was the date of that domestic violence alleged incident, and then a week later is the charge of OVI and endangering children. So there was a child in the car also. So she has concerns. On the domestic violence charge, we would be agreeable if Mr. Barker were to agree to take part in an assessment and recommended counseling having to do with substance abuse and mental health. And then we just have to wait for the urine results on the OVI to see how we're going to handle that. But certainly, if he would be willing to do that, and start in the counseling on the domestic violence charge, that might help him in everything that we're doing, including the endangering children charge. So even though we're not to the point there where we can make a recommendation on that, but it couldn't hurt. So if he wants to do that.
He's got an Ohio medical card. He has no problem having an assessment done.
Okay.
I don't know which agency.
Does he have a preference?
Where do you live?
Where do I live?
Yeah.
I stay in Cold Grove right now.
Cold Grove, Ironton area.
Bethesda? Okay. All right, Taylor, we'll talk to him about getting something set up for assessment. And so, let's see. What was the date of the ODI?
February 20th, Your Honor. Oh, well, was it 13th or 20th?
The 20th.
20th was the OVI, yes.
So May the 20th or thereabouts would be the 90 days. And but there's also this endangering charge too, which we feel like needs to be addressed through the counseling as well. So what we would like to have is a time waiver on everything.
We're still working on that.
That's part of the endangering. I wasn't intoxicated.
We're still going to argue that we're some of the domestic and the anger management.
Mr. Smith?
Yeah, Judge, we have no opposition to have an assessment for whatever Taylor deems necessary through Bethesda. He'll comply with that, but I would like to come back sometime a little sooner than later, just see how he's doing with his treatment. If he's
Well, let's make it April 24th. There's a chance we will have the results back.
first day of my murder trial in Ironton. I've got the whole week. Well, I can do the 17th.
Probably won't have, that would be
Or maybe, let me see if I can do the
probably 8 weeks. I don't think we'll have the results probably.
They've been getting a little more.
I'm here the 21st, April 21.
Let's try that.
Do that.
That's a Friday. Okay, this is continued to April 21st. And Mr. Barker is going to start some sessions with Bethesda, and we'll come back and report if we have the results on the murder string by then.
State of Ohio versus Arley D. Mans, case number CRB 22-521, CRB 22-528, and CRB 22-541.
This case, set for the trial.
His dad's right there, so I'm sure.
How's he doing?
There's no date. He says he got that last week. I didn't see a date on it anywhere. Thank you.
Roger.
Is this my copy?
You can have that, Judge, yes.
Well, Mr. Mans has done, I think, what we hoped he would do, and he's maintained his medical treatment and whatnot, and get a report from his father that he's doing well, and the rest of the family was aware that the case, we may ask the court to go ahead and dismiss the case today, and we don't have any opposition to that. I think that Mr. Mans hopefully understands this is a lifetime pursuit for him to make sure that he stays on the right path and cuts a lot of hair. And Mr. James is just proof that he's doing well. So we wouldn't oppose a dismissal.
We have no opposition to that, Judge.
Well, Mr. Mans, I would just say that I'm proud of how well you've done, and I agree with Mr. Hill that this is something that you're committed to long-term. And also, I'd like to have your recommendation, because I know you're one of the first people I've had that have referred to PATH, which was a fairly new facility in our area. And just for purposes of sending other people there, have you been satisfied with the services there?
Yes, I
Feel
have.
like they helped you?
Yeah.
Okay, well, I'll continue to use them and recommend other people go to that facility. So, all of his cases then at this point are going to be nominal.
Correct. Thank you.
Thank you, Judge.
It means dismiss. It's a fancy word saying dismiss.
Thank you, Your Honor.
You're welcome. Good luck to you.
State of Ohio versus Michael Gardner, case number CRB 22611.
Mr. Thompson's case.
Now, hopefully, Your Honor, you have a report from PATH.
Well, I do. I'm just not sure what the date is. They're not good about putting dates in.
You
I
said
got one in the file.
the 14th.
I think this is an old one because it talks about him getting his GED. Is it Mr. Gibson? Is that who he was working with? I think this was the initial report. I think Mr. Gibson, I can get him to respond pretty quickly. Yes. Let me send him a text, and usually he responds pretty quickly to my text.
Okay.
And I'll recall it after I get a response.
State of Ohio versus Ethan R. Anderson, case number CRB 2319.
It's Mr. Stratton's case.
Yes, Your Honor. Mr. Anderson has a pending case in felony court, so we're just going to set this for another pretrial. He has a pretrial later in the week. He's represented by Mr. Smith.
March 29th, Judge. He's in treatment, so we'll see how he's doing in treatment.
Okay, well, it's a pretty good report, but it looks to me like there's some things he's still got to work on.
Yeah.
Okay? And when do you want to come back?
It's up to the court.
When's your panel, please?
29th.
29th?
March 29th, yes, sir.
So sometime after that.
Yes.
April 10th?
Yes, that's right. April 10th. Thank you, Your Honor.
You're welcome.
That's great. Thanks. All right, see you.
State of Ohio versus Brandon M. Code, case number CRB 22777. Brandon Code.
Brandon Coe is not here.
Now, today, there was a discussion the last time that the case would be dismissed upon the payment of court costs if there were no further problems. So I don't know if maybe costs were paid, but the victim has, we've been in contact with her and there have been no further problems.
They have not been paid.
We don't oppose a continuance for Mr. Stratton to see
Yes.
getting paid the court costs.
Yeah, 7 days. Ask for 7 days, Your Honor.
I'm sorry.
We'll ask for 7 days before the warrant's issued.
All right, the warrant will issue in 7 days and he hasn't appeared.
State of Ohio versus Joshua Hinchman, case number CRB 23107.
Mr. Stratton's case, pretrial.
Your Honor, we'll plead guilty to the charge today. It's a theft. I think the state's going to recommend 10 days suspended, 1 year probation.
2 years probation. I mean, whatever the court does, whatever the court does.
Yes.
Well, my practice now is, because we have so many that are positive, I'd like for him to do a urine screen before I decide what the sentence.
Yes, Your Honor.
So they'll do a urine screen and we'll come back and I'll decide after that what the sentence will be.
Yes, Your Honor.
State of Ohio versus Jared S. Williams, case number CRN 2391. This is Mr. Holt's case.
Mr. Holt, Jared Williams. He was supposed to be at Riverside?
Yes, Your Honor. Your Honor, Mr. Williams was at Riverside with a GPS monitor. However, he cut his ankle monitor off.
Okay.
So.
After my talk, did I get him the 3-year in prison?
Yes, Your Honor. Yes, Your Honor, you did.
Okay. I must not be stern enough with that talk. I kind of scared myself when I did that talk, but I didn't scare him enough. This is a guy that got to go to treatment with an ankle monitor because of his past history. And I told him, if you're tempted to cut the ankle monitor, you'd be better off just staying in jail. Because you're going to go to prison if you cut your ankle monitor off. Okay, so do you want to send it on to the grand jury or just have a warrant from here? How do you want to proceed?
It would probably nominate to the grand jury.
Okay. be acknowledged to the grand jury.
State of Ohio versus Sarah A. Woods, case number CRB 22-326, CRB 21-686. Tyler Smith's case.
Judge, this is Mr. DeLauder for purposes of the record. I'm here because I represented Sarah down in Common Pleas Court, and I think you had maybe laid this over a few weeks until that case got resolved. I was here to just inform the court that we were able to get that case resolved. She is on community control sanctions down there out of Common Pleas Court, and part of her community control sanctions is a requirement that she complete a program, a rehabilitation program. My understanding is she's currently in rehabilitation with Lawrence County Recovery, is that right? And I think she's doing okay, although I haven't seen the report.
I just got the letter handed to me. I see a negative test for substances, so that's always good. So it looks like so far so good.
Okay. And I'm not sure what the status of this case here is, Judge. I was asking Mr. Smith that. I don't know if this has already been...
These were pre-trials on review.
Okay.
She had a warrant outstanding for missing review hearings. She's got a theft offense that's got some community service and fines due on it, and a criminal damaging, same thing. And part of that was for restitution. She has restitution and fines and community service.
Okay, so she'll still need to take care of her obligations to you then as far as restitution and community service goes?
Yes.
It doesn't look like the current balances reflect restitution. I was just checking on that. That was never put in. It said that it was jointly several, Everett Dean. I don't see restitution on either of those files. So I'll have to address that.
Okay, $600, joint several with Jennifer Woods. Well, Sarah Wood, the entry says Jennifer Woods.
On CRD 23-326.
This is 21-686.
And that was dismissed with my mom.
Criminal damage.
22.
That criminal damage, she thinks that charge was dismissed. Her mother was the complaining party. I don't know if that's accurate or not.
It looks like there's restitution on both cases, Your Honor.
Okay, let me look at the, I wasn't looking at the entry.
That restitution has been put on 21-686.
Okay.
22-326. I don't see. There's $500 restitution to.
Yeah, right. Everett Dean to Lulu's Smoke Shop. $500.
That's the,
So you have to take care of that.
Yeah, so there's actually even more.
She agrees. She does know that she owes the restitution to the smoke place, and probably owes you community service. I think I heard you say
Yeah,
that.
there's 5 days on that and 5 days on, she's got a total of 10 days.
All right. So can you start working? You got to work on those things. Could she have one more review hearing, Judge, and I'll get her to try to start.
Sure, we can.
Getting that stuff taken care of.
At this point, my attitude is her sobriety and recovery is #1 priority. But this is up there too. You need to take care of this, but get you clean and sober first, and then you can work on this other stuff.
And I won't be here with her for her review hearing in the future.
Yeah, you don't have to be. Mr.
Okay.
Smith's been representing her.
All right.
Here, so.
Good.
Let's just come back. Will she be able to do some community service while she's at?
Yes, absolutely.
Okay. Yeah, do some community service while you're at treatment. And let's come back in maybe 6 weeks. She's getting supervised by Common Pleas also, right?
She is.
Okay. So let's look, maybe May 15th, or more than 6 weeks.
That's fine, Your Honor.
May the 15th will be the next hearing.
You want this on the pre-trial docket, Your Honor?
I don't know if it's even necessary, Mr. Smith, do you want to stay on it, or? I think reappointed you because of the
Right.
warrant, and she had the outstanding thing in common.
And I was initially representing her in the Common Police Court, and then she retained Mr. DeLauder, so that's why we have two different attorneys here, but
I'll just put it on the review docket.
that's fine.
May 15th as a review. 9 a.m.
Thank you so much.
Good luck, ma'am.
Thank you.
State of Ohio versus Jessica Christian, case numbers TRD 222505 A and B, TRD 19255 A and B, TRD 183566 A and B, and CRB 181148. Jessica Christian.
Smith is representing Ms. Christian.
Didn't have insurance.
Oh, wait a minute, is that Jessica?
Is,
That's that Calzas, remember? He's on there,
all right. So, Your Honor, we've been trying to figure out the issue of restitution. I think that's Mr. Sias on the screen. He was driving the car of the non-at-fault party, and I believe, and Mr. Sias, you can tell me if I'm wrong about this, that the car belonged to someone who's deceased, maybe your grandfather or somebody? Oh, her car was being. And it was suggested last time that because Mr. Sias had insurance, that they could find out whether her insurance was, whether her car had insurance, because she was driving a car belonging to an individual who, who was deceased. It's almost too confusing for me to understand.
All right, Mr. Sias is appearing by teleconference. Can you hear what's the conversation so far, Mr. Sias?
Yes, sir.
Okay. And you were in a wreck with Ms. Christian in another vehicle?
Yes, sir.
And you had some damage
On
to
the
your...
27th, yes, on the 27th of September. She doesn't have a valid license, but she did have insurance.
Did you have insurance on your vehicle?
Yes, sir.
Did you full coverage or liability only?
Liability only.
Okay. Well, there's the problem. So I guess we were trying to find out if there was some coverage on the vehicle that she had, because it wasn't titled to her. It was titled to someone who's deceased now.
Yes, that's my understanding.
He's insured by a Century.
Mr. Sias is insured by Century.
That's liability.
And this is
only,
what
so-
she owes?
Yeah, I only owe 1,900 instead of 83.
All right. So apparently, she's going to owe this amount, $1,935.20.
Not 8,300.
That's, I can show you the letter, Judge.
I'm sorry, I didn't heard the 1,900, but I don't understand what you're saying. Is this what the damage was? To
That's what his insurance company sent me.
Okay. So apparently you had Century Insurance, but they didn't, Mr. Sias, I'm speaking to you. You had Century, but they didn't pay your damages but they did send a letter to Ms. Christian saying she needed to show proof or they were going to turn it into the state of Ohio that she was driving without insurance.
My insurance is Dairyland, I don't have state insurance.
Well, somebody submitted something.
This is the letter
For her.
previous to that one.
And it says the date of loss was September 29, 2022.
And then this is different.
September 27th?
Yes, sir.
Okay, well, maybe this is a different wreck.
Your Honor, this violation date is September 29.
Okay. Well, the clerk is saying this is showing in the computer as September 29th. Yeah, it is showing September 29th.
Me and him only got one wreck.
I brought that estimate from completing body shop, so basically the guy was telling me $8,500 is what it costs to fix and rebuild my truck.
Your Honor, I have another, there's two other things you can go from Central Insurance. That's in the fourth one, so.
Well, here's one from Dairyland.
Yes, so, but I believe Century's the Viking Corporation, that I guess they're
Maybe
subsidiaries.
related.
Yeah, so,
Now, Viking is through Dairyland.
right. So it appears that they're subsidiaries, so that's,
But you're saying you didn't receive anything from your company, Mr. Sykes?
No, sir, my insurance wouldn't cover it at all. I actually had to pay the total bill to get it out the income. It was a total loss.
And is this 1935.20, is that a fair amount for the damage to your vehicle?
No, it's $8,500.
We actually have an estimate for 831869. I don't.
Well, I believe the limit that this court can award on restitution is $5,000.
I believe so too. It seems that a lot of the solution to this is going to be found in the civil court.
Yes. Well, Mr. Sias, I'm sorry for your loss of your vehicle and the damage there. It's one of the problems of driving a vehicle in the state of Ohio, most states. If you don't have full coverage and the other person has no coverage that causes your damage, you're not going to be covered. Your own company's not going to pay, and they don't have any coverage to pay. Okay, sir, I didn't interrupt you, so you listen to me. I'm going to order that the limit of what I can order on these kind of cases is $5,000. So I'll order that. It's not self-effectuating though. I mean, we did away with debtors' prisons a few hundred years ago, so I cannot put Miss Christian in jail for not paying a debt. You have civil remedies. The problem there is going to be the same thing. It's difficult to get money collected from someone who doesn't have anything. If she has no substantial assets, it makes it very difficult to collect a civil judgment. Mr. Heald.
And, well, Your Honor, I believe that the court's restitution order in this case actually acts as a civil judgment as well.
Okay.
So there are civil remedies for that would be established just by the court's order here.
Which means if you can find an asset, you can execute against it, but you have to find the asset to execute against. So, all right, can we wrap things up then today?
Yes.
There is no apparent insurance insuring Miss Christian. That was the main thing we were trying to find out.
we were trying to find out if the estate had insurance at the time, and evidently there wasn't any insurance. It was an uninsured vehicle.
Your Honor, may I have the victim's name for?
Kyle Sias, K-Y-L-E-S-I-A-S. And I have an address for you, Mr. Sias, of 212 Sullivan Road. Is that correct?
Yes, sir.
Okay. I'm going to order that she pay the restitution of $5,000. If you want to seek Anything above that, you can file a civil claim, but I'm not allowed to award anything above $5,000 for restitution on damages in a misdemeanor action. So, I know it's confusing, but the legislature makes the law, and I'm supposed to follow what they set forth. So we've been delaying this on sentencing, so let's go ahead and conclude things on sentencing. Let's start with that one first. Is there anything you want to tell me, Mr. Sias, that you didn't get a chance to do?
Yes, sir.
Okay, I'm sorry about your uncompensated damages that you're gonna have. Okay, this is on 22-2505. So, there was a no operator's license and a speed offense. So on the no operator's license, I'll impose a $100 fine and court costs. I'll order a restitution of $5,000 for damages to Mr. Casillas' vehicle that weren't covered by insurance. I'll do level 5 probation with a review hearing of October 23rd at 9 a.m. She also had a sure clear distance ahead, which just means, sounds like you rear-ended him. You have, in Ohio, you have.
No, I should have been following for it behind.
You have to maintain your vehicle at a speed at which you can stop and ensure clear distance ahead. So if you run into somebody in the back end, it's going to be your fault, because you should have been able to come to a stop. Even if you come around the corner and they're just sitting there, you're not supposed to go any faster than what you can stop and how far you can see ahead. Okay, so I'll impose a $20 fine on that. Set review hearing October 23rd. 9 a.m.
Okay, thank you.
Okay, she's got some others. Got 2 more. She's got 19-255. This is from October of 2018.
I can't access that file, I don't know if someone else is kind of now.
Okay. And this was a driving under suspension also. And ensure clear distance ahead. I don't have any claim for damages on this one, so. $100 fine on the driving under suspension, court costs. And I'll just set October 23rd, level 5 probation. And there was a sure clear distance ahead on this too, the B case, $20 fine. Then there was 18-356.
I'm showing the B case on that prior charge was a child support suspension and not.
Oh, well, what was the A? I thought it should have been the A case.
It was a US as well.
Well, just dismiss the B one because it looks like it's the same. They were both driving under suspension. Then the C case will be the.
I don't have a suitcase on it.
Okay. It was marked on the ticket, but apparently it didn't get filed. Okay, then 18-11-48, she was already sentenced on that.
Yeah.
That was the theft.
Yeah.
Then there's also 18-35-66, she was never sentenced on. Was another driving under suspension. and failure to stop at a stop sign. $100 fine and costs. $10 fine on the stop sign. October 23rd for review. Level 5. She'll need to go see Mr.
Major?
Major. And here's insurance letters. Okay, that's all.
State of Ohio versus Tanner v. Howard, case number CRV 21427.
Okay, keep on the screen. This is Mr. Smith's case. Sentencing. That's a pretty good report. This is a fairly old case, but I think he was out of pocket for a while. He's been back in treatment, and it looks like he's getting pretty good reports.
Yes, Your Honor, he currently has a case pending in Common Police Court, which I represent him on, so.
Okay.
When's our next pre-trial, do you remember?
Wednesday.
This Wednesday? Yeah. Okay, I thought it was the 29th for sure. We're back in court on Wednesday, so we'll know whether we're wrapping that one up pretty soon, hopefully.
Okay, when do you want to come back on this one?
We could probably come back in 3 or 4 weeks maybe to see how.
April 10th?
That's fine, Your Honor.
April the 10th. For sentencing. Right.
April 10th. Thank you.
Here, Tyler.
State of Ohio versus Joshua Ramey, case number TRC 222516 A and B.
Mr. Holt's case.
Okay.
Your Honor,
Jim.
may I approach?
Yes.
Mr. Rainey went to PROACT for the assessment, and they concluded that he did not meet their level criteria for substance abuse treatment, but he is still willing to do outpatient.
Okay.
So I don't know where we would go.
Well, did he tell them everything? Because he has a second offense with a high test score, and under Ohio law, it's mandatory that he gets treatment. So
Yes.
what I find in a lot of these is people don't give accurate histories. And that, I mean, they are going off the history. So,
I had that same conversation with him. You already said, I had that conversation with him before the assessment, and he did inform them of both instances. He wasn't convicted of, I know it's written as a first, but there's no prior conviction. It was charged as a second, but there's no prior conviction.
okay, well, it alleges 1 and 22.
Let's see.
Yeah, it was a West Virginia stop that did not result in conviction. But he did inform them of both incidents.
So, yeah, the prior was in mayor's court, or not mayor's court, but magistrate court in Huntington. So, probably couldn't prove a second offense anyway, but we still would like to, it's 224, so it's.
He's willing to do that, Your Honor.
Okay.
It's just we need someone.
Well, the problem is he's got a West Virginia medical card, right?
Yes, so I mean, I don't know if they would still do it at PROACT. Did you have that?
Currently, I don't have a medical card because I got with my work and there was an issue when I put in for it. So I don't have anything from where I work right now insurance-wise. But when I went to PROACT, they did say something about they had a form for some kind of help to pay.
Sliding scale type thing.
I think so, but I had the money out of pocket that time, so I didn't sign for that help.
What did they charge you for the assessment?
When I went, it was, it was 100, they said 140 for the assessment, and if anything happened, I had to go back, it would be $60, $65.
A session?
Yeah, yeah.
Well, do you want to treat it as a first then, and what's the state's offer on this?
On disposition on the OVI?
If he enters a plea, what would the state
Well,
recommend?
we believe that it would be a first offense, high score.
Magistrate's court, even if there was a conviction, it's not a court of record.
And we feel like it's serious enough that we would want him to attend to his treatment. I don't know whether he's going to have a way to pay for it or not, or how that would go, and we would be willing to delay the sentencing and let him be successful in treatment and get some good reports.
Your Honor, the idea was, being a first offense, that what we were trying to do is he's fully employed, he has no, other than this, we believe it's an isolated incident. We're wanting to show the court the opportunity, or give him the opportunity to show that he was serious about it, and go to these counseling sessions and do everything he was supposed to do, and hopefully the carrot he chased, the incentive would be to treat it as a low offense. That was what we looked at.
Okay. Well, it sounds like he's going to have to self-pay since he
Yes.
doesn't have a medical card or health insurance.
He's a full-time employee at Walmart.
Yeah, if it's
He has
only
been for a while.
$60 per session, I can afford that.
Well, I don't know if that's what it would be at another facility.
Will they still treat you even though you didn't qualify for their, will they still?
They said I could sign up for counseling, but I pretty much just went in there and told them about both instances, and I said Judge Kaepernick wanted me to get an assessment to see how to further pursue it, and that's what I went in there, and then that's the paper they give me at the end of it.
Okay, so he's still willing to go?
Yes, yes.
Yes.
Okay, well, let's try that. Because I mean, I would be on board. What you're asking is a first offense, but a low test score, and he has a pretty high test score at this point. So, because what I want to be convinced of, Mr. Ramey, is that this isn't going to happen again. I don't want to release you to go out in the world and that you hit me or some of these other people or one of my kids while you're drunk on the road, or anybody else. and I want you to hurt yourself. So I don't want this to happen anymore. So whatever we got to do to get that through your brain, that you understand this is serious business and you can't do it, that's why you got to convince me. Otherwise, you're looking at jail time.
I understand,
That
Your
makes
Honor.
sense?
Yes, Your Honor.
Okay. So another month or so?
Sure, Your Honor. I've told him, I believe we'd expect him to go, we're expecting him to go at least twice a month. Is that fair?
Yes. What,
Any,
end of April or the 1st of May, what's your schedule?
would that May 1st work?
It should, let me check. Yes,
Thank you, Your Honor.
May 1st will be the next hearing. Pre-trial. Finished request.
Yeah.
Actually, sentencing.
I'm sorry?
Sentencing.
Okay, sentencing. So there's already been a plea. Yes, it was a sentencing today.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Courtney R. Hampton, case number CRB 22761.
Now approach it.
Yes.
So in this case, Judge, there were some further discussions after we were in court last time, and I think that all the parties at this point have reached a proposed resolution that they're all in agreement with. I've reviewed it with Mr. Heald. I think it's appropriate, given the circumstances here. I believe Mr. Heald is of the same opinion.
And after, I think, a mature reflection on behalf of the parties, I think Ms. Casey would be in agreement with this also. A 90-day continuance, and hopefully there's going to be no further problems.
So is my understanding it's going to be in order to stay away during that time?
Yes, and I think there already is one, and the contemplated agreement is that order would remain in effect for those 90 days. And also, I'll just say for the record, I know the complaining party had some concerns about this too, but part of this agreement is that Ms. Hampton does not intend to. This is similar to a case where there are cross filings, although one of the cross filings hasn't been found yet. Ms. Hampton is not going to cause that to happen, and she's agreed to that in writing today.
All right. I'll approve the proposed entry. So this case is continued to June the 12th, and it can be dismissed then if there's been no further problems without the appearance of the defendant?
That's my understanding.
Is that agreeable?
We don't oppose that, and you'll let us know.
Is that with or without cost, Mr. Hewitt?
I expected it would be with cost, but I did not clarify that.
Okay.
Yes.
All right, if the costs are paid, there's been no further problems, the case will be dismissed on June 12th.
Let us know.
Okay, entries approved.
All right, thank you, Judge.
You're welcome.
State of Ohio recalls Michael Gardner, case number CRB 22611.
I got a report that's still undated, but is he still going to?
He said today.
I understand, but it really doesn't tell me what he's doing other than he's there. It doesn't say what's going on. He's being compliant or not. It's kind of very generic report. So No, what does he say the status is? He missed, the only thing it does say with the date is he missed the session on March 12th.
I didn't know I had it. He didn't tell me. That's why I missed it.
Well, it says in here, Michael said, I didn't wake up until 6. It's pretty early, or maybe you mean 6 p.m. Doesn't say p.m. or a.m. We discussed potential consequences of not complying with court order. Anger management is every Sunday at 4:30 in the Chesapeake office. He will be meeting with a therapist to review and implement skills. So is that still going on? Or?
Yes.
Yes.
It's going to continue to go on?
Well, he's agreeable to it, yes, absolutely.
Okay, well, I guess we'll see what the state wants.
I've been speaking with Michael's father, and he says that he's doing well at home and things are going great. The victim is his mother, and we have spoken with her in the not too distant past, but we want to make sure that she feels the same. Not that we think that he's being deceptive or anything, but we'd like to get confirmation, and we would like to have Michael continue on the path for another period of time, see how things are going. That's okay.
We're agreeable.
Okay. Do that May 1st date? That's a Monday.
Yes, sir.
May the 1st will be the next hearing. 10 o'clock. Continue with your sessions at back.
State of Ohio recalls Joshua Hitchman, case number CRB 23107.
Well, I think we need to have some help.
Yes. Yes, I believe that is positive for,
Yeah.
and we, yeah.
Do you have a West Virginia medical card?
Yes.
Have you ever been to treatment before?
Halfway houses and stuff like that.
What's your current status?
Nothing.
Well, I want you to go, where did you go in the past? Just a sober living type place?
Yeah.
And you live 1406 3rd Avenue, is that right?
Yeah.
Okay. Well, there's OVP in Huntington, which is going to be on 6th Avenue and 20th Street. It's walkable from where you are.
Let's do that then.
Is there anything?
You want to do something in Ohio?
Yeah, that's it.
Well, you have a West Virginia medical card,
West
though,
Virginia
right?
medical card,
Right.
so,
Now, the only place in Ohio that can take you is OVP.
yeah.
And you might as well go to the one there close, there's the one over, there's one in Burlington, but that's a lot further away from you.
Okay.
And I don't know if they do outpatient there anyway, that's where their inpatient facility is.
I got you.
So,
Yeah, so OVP, so we'll get an assessment done.
do you know where the facility, do you know which one I'm talking about on,
I can figure it out.
okay, do you know where the football stadium is?
Yes.
Okay. Walk up 3rd Avenue till you get to the football stadium, make a right, walk out 20th Street, 5 blocks. No, it won't even be 5 blocks, it's on 6, it's 3 blocks. It's on the corner of,
I know what you're talking about.
it's on the corner, it used to be an orthopedic surgery facility there. It's now OVP. It's right across, there's a fire station on the left, it's on the other corner. So, go there, I think you can just walk in. tell them why you're going, what you've done, that you got shoplifting charge, conviction, and that part of that.
Okay.
You have to go to treatment. So, did you want to get caught when you went to Walmart? This was a Walmart. Yeah, it was Walmart.
Yeah.
Because I've been told that people have been going to Walmart because they want to be forced to go to treatment. I don't know if that was your case.
I don't think that's the case here, Your Honor, but I've heard that also.
Because if you want to get caught shoplifting, that's the place to go.
Yeah.
They're going to catch you.
Yeah.
I don't know why people think they go there and shoplift and get away with it. You can't. They've got a SWAT team in there. So, back to making good decisions. Not a good decision to shoplift at Walmart. It's not a good decision to shoplift anywhere, especially at Walmart. So, and methamphetamine is not a good decision. It will mess you up over time. And right now, you think you're getting methamphetamine, you don't even know that you're getting methamphetamine. It could have fentanyl in it. And that can take you out immediately. Meth probably won't take you out immediately, but the fentanyl will, or can. Meth takes longer. If you just use meth, 3 years, you're going to age 30 years.
Yeah.
You use it for 3 years, you'll look 30 years older. Lose your teeth, get sores, all that good stuff. So, my message to you is, this is stuff you got to get off of, and this is a chance for you to do it and
I appreciate it.
turn things around. Okay?
Thank you.
Okay, I'll impose a $100 fine and costs. I'm going to make it 30 days in jail, all suspended. 5 days community service, and you got to go to treatment with OVP, and they'll give me reports as to what you're doing. You'll come back for a review hearing. I'm ordering you to stay out of Walmart stores as part of your probation.
Okay.
And let's see let's make it May 1st. It'll be your first review hearing. You got to come back here at 9 o'clock.
Okay.
If you don't show up, you get a warrant.
Thank you.
Go see Mr. Major in the probation office to the left as you leave the lobby, go 90-degree left to the probation.
Thank you.
You're welcome.
State of Ohio versus Hannah Gooden, case number TRC 222509, A, B, C, and D. Hannah Gooden, she did not check in, Your Honor.
She is on blue jeans, Your Honor.
Okay. You're right. I think I did see that. So she's got herself video and audio off. Ms. Gooden, if you can hear me, you need to turn those on. Hannah Gooden. I don't have, they're off, but the way they're marked means I'm not in control of it. She's controlling it. So we'll come back to her. You want to text her or get her on?
Yeah.
State of Ohio versus Kara D. Hearn, case number CRB 2381. Kara Hearn.
Your Honor, Karen's at,
Bethesda.
what's she doing? She was just here. Does she know?
I was going to order her to do your urine screen.
Yeah, she from,
She was just here, Your Honor.
If she is here, I'll order her to do a urine screen.
That's been my theme for the past 2 weeks, Your Honor.
State of Ohio versus Zion Sloan, case number CRB 19805. Zion Slum.
Your Honor, he's just paying costs, but I know there was a period, sometime in the past where he didn't show, and then this was put on the docket for today, and I'm not sure if he's shown since then, or?
I'm showing he only owes $10, is that right?
That's correct.
I think his lawyer would pay that.
Well, I don't know about that. He's been here multiple times, he's continuously tried to pay. Maybe the court will just write off the $10? Okay.
Paid on Valentine's Day, $140. Okay. I'll take it under advisement. I'm going to say that on the record.
Okay.
State of law recalls Casey A. Barker, case number CRA 21-614, TRD 122915, A, B, and C, CRD 11849, TRD 11349.
All right, Mr. Barker is here, who was late for review, right?
Yes,
Okay. How are you doing?
I'm doing good.
Are you working?
Yeah,
Where?
PCM,
Right down the road?
machine shop right over here. Recently got a promotion there and everything.
Very good.
Yep.
Well, I was kind of disappointed when he didn't show up. I thought he was doing really good.
I'd let my cousin take the car this morning. I forgot I had court, and she didn't get off till 11, so.
Okay. Can you pay anything on your fines?
Not till Thursday. I'd forgot all about it.
Okay. I'll reschedule for April 3rd. 9 a.m. No warrant today.
Thank you, Your Honor. I'll come in Thursday and pay on that.
State of Ohio versus James Butts at the Lawrence County Jail, case number CRB 21-9. And Brandon McClaskey.
All right, James Butts. All right, and let's see, who was representing Mr. Butts?
Your Honor, it was marked down on the list here as mine, but I guess you handled it after I left.
Well, kind of made a decision that he wasn't ready to go to treatment on Friday.
Okay.
So I wonder if he's ready today.
Yeah, apparently he is. So.
All right, Mr. Butts is at the jail, has been there over the weekend. We were looking for him to go to treatment, and this is the one where you called Ken Bolin and...
Yeah.
At Central City?
Central City Marker, yes, Your Honor.
And it's not operational?
It's not open at this time, Your Honor, but he did say that when it opens back up, that Mr. Butts would have a job.
Okay. Probably like for him to be clean when he comes to work with me.
He said he was praying for him.
All right, so we got you some prayers on the way by calling your employer and letting him know where you are. Is that?
I appreciate it.
Okay. And you're ready to go to treatment now?
Yes, sir.
And let's see.
Brighton Days was the one you told us to pick him up.
Are you,
Brighter Days.
I know, are you more ready to pick, I think you were a little afraid to put him in the car on
I'm
Friday.
ready to take him whenever he's released.
He looks a little less agitated today.
He does.
Yeah.
He does, yeah.
So how was your weekend?
It wasn't too good.
Okay,
It's getting better, though.
good.
Thank you.
Well, hopefully it's going to get even better. I'm going to release you to go to treatment at Brighter Days, and you all can pick him up today.
Is there any way I can get hygiene clothes and stuff off the meter?
Yes, we've got a group that's going to do that for you. What size do you wear?
Large, 32, 8.
That's not large, that's kind of, yeah, it's our 32, that's pretty skinny. And what about shoes? You need shoes? How about some running shoes? What size do you wear?
Yeah.
11?
Gotcha.
Have you got some? Because I got some around maybe a little bit bigger than that. Okay, well, I think we got you covered then. Okay, I'll release you to Mr. Hill.
Well, this just happened on Friday. I don't have any notes about, was he just arraigned on Friday? Did he plead?
He pled guilty, didn't he?
Okay.
Well, I don't know. I mean, it's on this docket as mine.
Okay.
But I wasn't here when you handled it, so I assumed
I think
that.
I appointed you after the fact.
Okay, all right, that's what happened.
He wanted to go to treatment, but we kind of felt like he was going to like jump out of the car when it was going 70 miles an hour down the road. Is what I felt like might happen. So I didn't think it was safe for him to go then.
Yes. So he pled, and are we going to set it for sentencing?
Yeah, we might as well do that. This is delay sentencing. I'm going to release you on a signature bond to go to treatment. And the main thing is you get clean.
How do I get there? You go pick me up or do I have
You got people?
Yeah.
Good for you. Everybody needs people. They're going to come, you're going to have more people now because you got other people coming to get you, right?
Okay.
Brighter Days they got people and their people are coming to get you.
What's the amount there?
Let's make it a $1,000 OR bond and set sentencing when Mr. Stratton can be back here in 2 or 3 weeks. What do you think?
Yeah, whatever.
April 17th?
Yes, that'll work.
Okay, we'll see you about 2 or 3 weeks. I think it's 3 weeks. The main thing for you is get clean, and you'll have a place to stay, and then Mr. Bowen will be looking for you to come to work when Central City work opens back up sometime. Yep.
State of Ohio versus Brandon McClaskey, case number CRB 22565. Brittany Stroud is on deck.
Your Honor, Mr. McClaskey had cases pending in Ironton Municipal Court, which we resolved last Thursday. And we made an agreement in that case that also would include a recommendation in this case. In that case, he received 180 days in jail with 150 days suspended and credit for 14?
Yes.
We had agreed that if he got the same thing in this case, that we would ask for them to run concurrently.
Okay. Is there, now I'm looking at the affidavit in this. Is this his mom was the victim?
No.
Because it looks like there might be some restitution, according to the affidavit.
Oh, yeah, that is right. $150 for the broken phone and $409.39 for the windshield.
Sure.
Brandon, you've got around $600 worth of restitution that has to be paid, and that can be paid over time. Okay?
You're going to confuse them out, they're the same person?
Yeah, I think they're to
Lily
Sally Chapman?
Lily Chapman.
Lily Chapman.
Kind of like LM1.
Yes.
And I'm sorry, what were the jail days again that's concurrent?
180 with 150 suspended, and now
Credit for.
it'd be 18 now.
All right, Mr. McClaskey, do you have anything you want to say before I sentence you? All right, I'll accept the plea and the recommendation of the state and the defense, and sentence to 180 days in jail, suspend 150, give credit for 18 served. This will run, it's concurrent with Iron Municipal, right?
Correct.
It's Iron Municipal, not common plea. Restitution of 150 for a broken phone, 409.39 for windshield to Willie Chapman. Review hearing October 23rd, level 4 probation for 2 years. This review hearing is October 23rd of this year at 9 a.m. That's all.
Thank you.
State of Ohio versus Brittany Stroud, case number CRA 23-152 and PRD 17-1084. Jennifer Pickerman is on deck.
Brittany Stroud is Mr. Holt's case. She's got an old case from 2017. It was just a driving under suspension that she didn't take care of, $50 fine and costs, and didn't appear for a review hearing. And then she has a warrant from Michigan, I believe it is.
Yes, Your Honor. Would the state be willing to consider it a time served on the $50 fine since she's been in jail for?
I don't oppose that.
Case number is 23-152. And you want the old case?
Yes, whatever.
17-1084.
Your Honor, we ask the court to consider that the U.S. time served for the fine or time served.
17-1084, I will finish by jail time.
And she would like to waive her right to an extradition hearing. And we ask the court to give us permission in 7 days to pick her up.
Well, I'm going to give them at least that long. We can set it for another hearing. All right. She can't, I set bond at 10,000, which I think is very reasonable. She's not going to be able to post that. So Michigan needs to be notified she's available to be picked up immediately. And let's give them a deadline of next Monday, the 27th, by 8 a.m.
We'll set that for next Monday.
Then I'll put it on, if she's still in the jail, I want her on the docket at 10 a.m. That's March 27th. that waiver, we'll review it. Mr. Hall, will send it, fax it down for her signature.
State of Ohio versus Jennifer Pinkerman, case number TRD 162635. And Doreen Waller is on deck.
And you're Jennifer Pinkerman? I'm not getting your audio. Must be it's probably turned off on the headset somewhere. There's a switch that seems like it gets turned off easily. I can. And you can hear me?
Yeah.
All right, I'm Judge Capper at Orange County Municipal Court. It looks like you had a prior conviction in this court for trespassing and parking in a fire lane back in 2016. You didn't take care of that. A warrant got issued for you, and you got arrested on the warrant. So you have a right to remain silent. You don't have to say anything about this, but if you do, it's going to be, could be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yeah.
Do you admit or do you deny you missed your hearings in this court?
At that time, I was going through a divorce, so anything that had gone through on that address or that phone number was looking like a phone, so I was about to get kind of info from him. So I don't think anything that needs to be cleared up because I did my community service. I had one for the client and I left the name, but since then, I mean, I've not been in any trouble. I've held out a job, got testing on my kids and everything else. I've been doing really well. What am I mean, like, what is it that I have to do with?
Well, I'm not showing that you did anything. You had
Yeah.
a total of $310 in fines and court costs, and it looks like a total of 30 hours of community service. I'm not showing that you did any of the community service either.
Yeah, my community service is only done for all that information to be sent to you guys.
Well, it wasn't apparently, because I had nothing in the file showing that you did any community service. So how long have you been in jail now?
I've been here since Saturday morning.
Do you have other charges? Is this the only thing you have?
This is the only thing I have. I've not been in any trouble at all.
You still live in Huntington?
No, I live in Pleasant now.
How'd you get picked up on this warrant?
I just went to my husband's show, and apparently it came up whenever we got pulled over on my ID. And my social records this morning.
Okay, what county were you in then?
I was in Guyana.
Okay. Well, you had 10 days in jail suspended to community service. Do you want to do the community service or you want to do the rest of the jail time?
I want to do community service, so I need to get out of here. I got to get my all this stuff.
Okay. Well, if you think you did community service, you need to, get a record of that at wherever you did it and get it filed with the probation office.
I absolutely will. I will make sure I get that done today.
All right, I'll find you in contempt for not coming to your hearing previously back in 2016. I'm going to set another review hearing. And we don't send notices to your house. I'm going to tell you now, this is your only notice. So, to make it memorable, I'm going to pick May the 1st.
Okay.
That's the first Monday in May, May 1st. You have a hearing, in this court in Chesapeake at 9 a.m.
Okay.
Now, if you get everything finished, these hearings are just to make sure you do what you're ordered to do. You've got 5 days of community service to do and pay $310 of fines and costs. If you do that before May 1st, you don't have to show up. If you haven't got it done, you got to show up. Or if you get a warrant, if you don't show up.
Okay.
You have any questions?
No, sir.
You'll get out and we'll send the paperwork down to release you later and you'll get released then.
All right, thank you very much.
You're welcome.
Thursday, we just get that,
You can come out. She's gone.
State of Ohio versus Doreen Waller, case number TRD 221656 A and B, and Willie Linville is on deck.
And ma'am, are you Doreen Waller?
Yes, sir.
Ms. Waller, it's, you've got a charge that looks like you failed to appear for, and that's why you're in custody. It's from last summer, June the 13th of 2022, in Perry Township. It's alleged you were driving a vehicle in with a suspended license. That's an unclassified misdemeanor. Maximum penalty is 500 hours community service, $1,000 fine, and that you were not displaying plates on your vehicle. That's a minor misdemeanor. Maximum penalty is $150 fine.
Yes.
Do you understand that charge?
Yes, sir.
And you have a right to remain silent. You can't have a lawyer appointed because these aren't jailable offenses, but you can have a lawyer, but you have to hire one if you want one. Because I can't, although you're in jail for not coming to court. You're not in jail for these offenses. So you're going to get out of jail eventually. But I can't appoint a lawyer for you. You can hire one if you want. And you have a right to make the state prove these charges beyond a reasonable doubt. Do you understand those things?
Yes, sir, but it's not necessary. It's like pretty tested that.
So how do you want to plead to these?
I'm sorry.
How do you want to plead to these charges?
I'm going to go ahead and plead guilty to these charges.
I plead what?
Plead guilty.
Guilty, okay. That's what I didn't understand. All right, I'll accept your guilty plea. When did you come into jail?
Yesterday morning, I think around this time yesterday, drone video or whatever.
Okay. What happened to cause you to come in jail?
My daughter's in rehab enforcement, and we were going, I was riding with my son-in-law to enforcement to visit her, and he got pulled over, and they read my name, warrant came out, and they brought me into where I'm at now.
Okay.
I was first with Fulbrook, John.
What about Colgrove?
He was driving through Fulbrook when he got pulled over.
Oh, okay. Was he speeding or what?
I'm sure, I think that they recognized his van from a previous time he had been pulled over.
Okay. Well, you gotta come to court. If you don't come to court, bad stuff happens.
Right, yes, sir.
Okay. Do you have a driver's license now?
No, sir, right now I'm not able to get a driver's license because of the seizure. They said that I have to be still on without a seizure to get a medical doctor's clearance, and I haven't been able to do that so far.
Okay. All right, well, I'm going to release you from jail. On your driving under suspension, I'll impose a $100 fine. And no jail days. It's not a jailable offense, actually. On the license plate, a $50 fine. And I'll give you a final pay date of June 27th. You got till June 27th to pay it or we'll send it to the DMV. She doesn't know. And you won't be able to get a license. Okay, you'll get out of jail today. Any questions?
No, sir, yes, sir, I do. Community service,
I didn't give you any community service, but you can work off your fine, and you can get, if you come Thursday, you get double credit. You get $100 credit Thursday for working at the court in Chesapeake. Well, just this Thursday. Yeah, we got a special project, that's where we're trying to lure people in by giving them double credit. And you've got also April 29th, you get double credit. So, okay, you'll get out here shortly.
All right, thank you, Your Honor.
Unless you got something else that I don't know about.
No, sir.
Okay.
State of Ohio versus Willie Linville, case number CRA 23-157, CRB 16-350, CRB 14-674, and Ryan Mount is on deck.
This is Mr. Holt's case, and there he is.
I believe we're picking him up at 2:30.
And he's getting a...
Ankle monitor.
Okay, he is getting an ankle monitor. And everything still go on that?
Yes, Your Honor. As far as I know, Mr. Linville does want to go to treatment.
Okay, we're giving you an ankle monitor, you're gonna go to treatment. I think I can say this, and Mr. Holt will agree with it. If he doesn't, he'll say, the best thing for you can do personally and legally is get really good reports.
Yes, sir.
In your treatment. Mr. Healy.
Well, Your Honor, that goes especially so because this is a third-degree felony. So it would be just as easy for us to say we're just going to take it to the grand jury. We're willing to give Mr. Linville a chance, but he's going to have to do really well. Now, on another matter, if the court doesn't mind if I address this, he's got an old shoplifting charge that was never resolved from 2014, and it's alleged he stole a bucket of chicken at Walmart, but I do not believe we are able to prove the case at this point. As much as we would like to, we searched for proof of the bucket of chicken, found no bones anywhere, so we have to dismiss that charge.
So I can beat this, if I want to shoplift some chicken and can stay on the land for 9 years, I can beat the system.
If that is unfortunately a lesson to be learned from this, that it is possible, but by golly, you better stay hidden as far as all I can say.
I have tried my best, I'll stay out of trouble.
Okay. Well, the thing you should take from this, though, and we just had this happen this morning, so I got to give you my ankle monitor speech. Because believe it or not, somebody, I don't know if they were in jail with you earlier, but I put somebody in treatment with an ankle monitor, and I told them, if you cut the ankle monitor, you're going to go to prison for 3 years. And guess what? They left treatment and cut their ankle monitor. So when they do get caught, they're going to go to prison for 3 years. So, and I always tell people, if you feel like you're going to be tempted to cut the ankle monitor, you'd be better off just staying in the county jail. And you'll get the treatment probably down the road somewhere, maybe Star, someplace where it's harder for you to go to prison. But if you agree to go to treatment now with an ankle monitor, leave, cut the ankle monitor, and I know this because we've had other people do it, and this is common pleas. You'll be away from me. You're going to go to the common pleas court then, and they're going to send you to prison for 3 years. Do you understand that?
Yes, sir.
So, now, the other side is do really well, because you've got a more serious charge than our typical possession. You're like a step up. So you really need to go some, because they could take your case to the grand jury, indict you, send you down to the other court where you got a 50-50 chance of going to prison anyway. You don't want that, do you? You don't want that. Do you feel lucky today?
Yes, sir.
Well, you feel lucky because you're going to treatment, but do you feel lucky like you might get the right draw and not go to prison if you go to common pleas? You never know. It's like playing Russian roulette. Spin the barrel. What? You get an empty chamber, or you get, those are your two choices. You get an empty chamber, or one with a bullet in it.
Well, one of those would be a bullet in one.
So, go to treatment, do well, get really good reports, and maximize the chances that you're going to stay here in Lawrence County rather than go to one of those prisons. You know, that's not, the prisons aren't like Lawrence County. You understand that? I mean, you might get down in Scioto County, but other than that, it's like Ohio, not Ohio. You don't want to go to Ohio. I mean, they like to chant Ohio, but they don't like Ohio. The people that chant Ohio don't like Ohio. And the people that like Ohio don't fit in Ohio. So stay down here. And you got to do well in treatment to do that. Does any of that make any sense? He's thinking the judge is losing it.
Took me a minute to understand what you were saying.
Yeah. Okay, you're going to get picked up and then come back when?
How long do you want to go out there?
Couple weeks probably.
We do the 10th,
April 10th. That is a fact. They never chant Ohio, do they? Never. Ohio.
They don't claim this either.
It's like, once you get the chill coffee, you're on your own. That's not a part of Ohio. You can see those hills as you're driving down 23. You get toward Chillicothe. There's the hills. That's where it starts.
State of Ohio versus Brian Mountain. Case number TRD 21-1476 A, B, and C. TRC 20-2545 A, B, and C. TRC 19-2270 A and B. TRD 20-2139 A and B.
But those hills go north. When I went to Zanesville when the Fairland Girls, oh my gosh, from Athens to Zanesville, I thought I was in McDowell County, West Virginia. I'm not kidding you. Yeah, the Appalachian Mountains run northeast, and that's, I mean, it's hillier there than it is here. And the roads are not in very good shape either, from Athens to Zanesville.
James C. Elkins is on deck at the jail.
Okay, we've got Mr. Steyer here, Mr. Mount is at the jail, and I think he's got some stuff in common pleas, doesn't he?
My understanding is he has something in either municipal or is it common pleas, I'm not sure which.
It's common pleas. He's got a community control sanctions trial this Wednesday.
Okay, he has a CCS trial on Wednesday in common pleas court.
And we have a result from that?
Well, it's on Wednesday.
Oh, it wasn't last Wednesday.
No, it's coming up on Wednesday, apparently.
And this is dispositional stuff, I believe, here.
He failed to appear. I think there's still some stuff that's just pending. It's a traffic matter, 21-1476. Also, well, he was sentenced on it. There was an ODI. He had been convicted on, and he was supposed to be going to PRO Act back in 2021. I don't think that happened. He's got an ODI from 2019 that's still not completed.
Oh, Your Honor, apparently that was somebody else that has a CCS trial on Wednesday.
I think he's got something in our municipal court.
That was my understanding.
He got pending felony drug charges in Ironton Municipal.
So they're, okay, so
We got a preliminary on
they're just not into, they've not gone to common pleas, don't know if they will or not, obviously, at this point.
Are you representing him?
I haven't been appointed to him yet, now that may be, has he gone, have you gone to municipal court yet?
Yes, sir.
Do you know who was appointed to you there?
I don't know, that wasn't you.
Okay.
Had other things?
That makes sense, Mr. Meadows.
And you probably haven't met him yet, have you?
Excuse me, Mr. Chairman.
You probably haven't met your lawyer from our municipal yet, have you?
No, sir.
I'm here Friday. Do you know if he's on for Thursday, Phil?
I'm looking.
If it's a felony, he probably is on for Thursday. In which case, I'm here Friday, we can bring him.
Guys here just told me I go to municipal court Thursday.
Okay. Ask to bring this back on Friday and I'll talk to Mr. Meadows Thursday and find out what happens. And Mr. Hill will know what happened as well, obviously.
I don't know what the seriousness of those are, and I don't know if this is appropriate to say, but I'm going to say because I've followed Ryan for a long time. He's had serious substance use problems, and that's his main problem that needs to be addressed, and I'm on board with however that can be addressed.
Well, what I would ask then is that for now, and we can revisit this Friday, if we could set an OR bond that would be eligible only for release to a treatment provider, and then if on Friday we find out we need to do something else, we can revisit the issue. But that way, if Judge Waldo does something similar, he'll be able to go ahead and get somewhere Thursday.
We're not opposed to that. I don't know whether that's what's going to happen.
Right.
His most serious charge is a second-degree felony trafficking charge. So it's a little bit more serious, and Mr. Meadows is his attorney.
Okay. I'll set his bond at $2,000 OR for purposes of being released to treatment.
Thank you.
So that won't hold up Iron Municipal if they want to do that. And then reschedule him for this Friday, which is the 24th of March.
Or is there a particular provider that you want to use?
I'll let
Just for
them,
self-report?
I'm assuming that they'll take the lead on that.
I mean, from the sound of things, this may not even be something that's going to happen on Thursday if there's an F2 involved, but
Yeah.
my thought was just have this not standing in the way if they can get him into somewhere, and we just get him back here Friday anyhow.
Right.
And if we come back Friday and find out that, this is not on that sort of a path, we can decide from there what we want to do.
And I'm sorry, I missed that. Was that coordinated with Iron Municipal or Common Police?
Well,
You'd be under municipal at this point.
at this point, they could be going to common police.
Right.
So we'll put him on for Friday and see what happens at the hearing Thursday.
Thank you, Your Honor.
You're welcome. You understand, Mr. Mount? I've given you a signature bond, so if the judge there in Ironton wants to send you to treatment, I'm not gonna hold you out, but I'm gonna let you get released to go to treatment.
But only to treatment.
But I can't guarantee you that that's gonna happen. We'll see. You'll find out Thursday, and then I'll see you Friday for a follow-up to see what is happening on your case. Okay. Well, you can have Judge Waldo call me and I'll tell him what I just said on the record, your main problem is substance use. I think you're a pretty good guy. If you got your substance use under control, you could be a productive person. Well, you can tell your lawyer.
Everything here was special prosecutor.
If you get to talk to him.
I'm not going to test.
Well, I know. I know, that's about all I should say.
State of Ohio recalls James C. Elkins at the Lawrence County Jail, case number TRC 218058 AT&C, CRA 19790. He was in jail and was basically
Okay.
That was a long time ago. Say one of the Andersons.
All right, James Elkins, you're on the docket here for a review.
Yes.
But you're in jail. That's not good. Why are you in jail?
Well, the last one that I had with you, I went back to ODP and then Lawrence County Judge picked me up and brought me down here for probation, and I guess for using the drug analysis that I had at ODP to violate. That's what I'm doing.
So that's in common pleas?
Yes, yes, sir.
Okay. Well, so that's still hanging out there, that hasn't been resolved yet? You're gonna have to have a hearing on it?
Wednesday.
Okay. Well, I'm just gonna pass everything here to another day, because I don't know what's gonna happen with you on that. You have been doing well, so.
Yeah, I thought so.
Okay, so let's put it off for another month. I'll set you for April 24th. So that is the last Monday in April. You'll be your review hearing before me. So if you're out, you need to get here on your own. If you're in jail, then I'll see you just like this in teleconference.
I sure will.
Okay.
All right, thank you.
You're welcome.
We're finished at the jail.
Okay, that finishes us up at the jail, we think.
State of Ohio versus Kara Hearn, case number CRB 2381 on a recall.
Your Honor, she's here now.
Oh, she's screening?
Oh, okay. But she was not on the docket, so that, but she was.
I had it. It was on my docket.
Well, that's all that matters. But she appeared by video that Monday or Friday, and then you told her to appear Monday, so there was some confusion about the docket, so.
We have a result?
She didn't go.
I didn't go yet.
Well, I want her to go. I'll wait. I can outweigh you.
Okay.
Okay.
State of Ohio recalls Hannah Gooden, excuse me, case number TRC 222509 ABCD.
She should be online.
I think she is. She was a minute ago.
And paying attention.
No, she's gone.
She's gone?
She was there a few minutes ago. And now she's not.
Herding cats.
Well, this is a good place for that.
So she's supposedly an OVP?
She is at OVP. Her counselor was out Friday, and her counselor's out again today, so we do not have a letter.
Text her?
I did. I'm waiting for a response. Your Honor, she is not answering. She was on all morning, and,
Well, I went to her once and she didn't answer. I mean, it was showing, it had her name up, but she didn't answer. But then later I saw her image was on there while I was dealing with other people.
yeah, that was after I texted her, told her that, put her audio on, and then she disappeared.
Okay, well, she's got 7 days to get in before warrant issues.
Okay.
And then get a urine screen from Kara while we're doing that. Talk to,
Well, she's reconnecting now. Her tablet died, Your Honor.
okay.
I'm sorry. Yes, that works. No, she's already cleared.
Oh, both of them are sentencing. She said she's sorry for the delay, give her 2 minutes max.
Okay, started now.
There she is.
I'm so sorry, technical difficulties.
Okay, so you're still at OVP?
She is.
Yes,
Now, are you outpatient or inpatient at OVP?
I am out.
Okay, the last report I have from them is December, and you were outpatient then, so.
Yeah, and I believe that was a very good report, Your Honor, from December. But like I mentioned before, her counselor was out Friday and is out today, so we do not have a letter today. We can set it for, yeah, she can get it tomorrow if the court wants it tomorrow or the next time.
Well, I think we need a report, and it's time to do something with this case. Is this on, yeah, it is sentencing. She
It is.
pled guilty back in December.
Right.
So give me some reports, and then I would like for you to come in person to your next hearing. And let's see, you're living in Ashland?
Yes,
Okay, so she should be able to get here for next hearing.
No problem.
What date do you want to come, Mr. Stratton?
Whenever the court's convenience.
a Friday would be preferable, because that's the only day, well, yeah, Friday if possible.
Fridays are better?
Yes.
Yes.
April 14th.
April 14th.
April 14th for sentencing. And be
But
present.
my last report is a good report. He had passed out, he did have to leave for an emergency on Friday. That's usually when I go pick him up, and he's not in office on Monday mornings.
Okay.
Okay, we'll see you on the 14th of April. We need a report then also.
At 10 a.m.
10 a.m.
Right.
Correct.
Thanks, Hannah.
Thank you so much.
You're welcome. Okay, so court will be in recess while we wait on Ms. Hearn's test results.
So I was, it's sort of been a